I want to turn it back over to you, Mr. Johnstone, for any closing remarks you might have.
Oh, thanks. Well, I mean, the first, again, keep your secret secret. When you go into court, you have to establish that it's a trade secret in the first place. So you really want to be proactive and think about that. Second, as I mentioned, is, consult with an attorney and determine what's the best method of, what's the best kind of intellectual property to protect your stuff. There's a huge amount of litigation about this and a huge amount of, at least alleged theft of trade secrets. So you want to protect them. And the more proactive that you can be in what form of intellectual property you use and having your ducks in a row if you have to go to court, the better. And if you're negotiating with someone to hire them, make sure that you have protected yourself against any charges that you have hired them for the purpose of taking their trade secrets, taking someone else's trade secrets. If you're an employee and you're really smart, you know all sorts of good stuff, and you're moving from one company to another, keep those issues in mind because you don't want to be dragged in a litigation between two companies that are kind of using you, making you the subject of their litigation. So let's say you get an employment contract that's been given to you and you go to your attorney, you're probably going to ask them about all sorts of things, but maybe this should be on your list as well so that you understand any exposure that might exist and the limits on what you'll be able to do if a suit is filed.